Hello to our live audience, and welcome to all those who might join us through this recording at a later date. I am pleased to welcome you all to our third session this season in the context of the 32nd Vis Moot, brought to you by Africa in the Moot with the support of our media sponsor, the Arbitration Channel. My name is Ghada. I'm a lecturer of law at the Royal University for Women in Bahrain, and I'm the deputy chair for Africa in the Moot's Education and Training Committee. A brief introduction about Africa in the Moot. It is a volunteer-based nonprofit organization dedicated to increasing the representation of African teams competing in the VIS and their in-person attendance in Vienna or Hong Kong. Before I hand it over to my co-moderator, Oscar, to briefly introduce himself and our guest today, if you have any questions, please feel free to use the chat. We might ask them to our guest speaker during the lecture, or we might leave some till the very end. Oscar, to you.
Thank you, Ghada. Excited to be here with all of you. My name is Oscar Wandera from Nairobi, Kenya. I'm a dispute resolution associate at MMA Advocates that's in Kenya. I had the privilege of participating in the Vis Moot, particularly the 28th annual Vis Moot, and it was really an enlightening experience. I hold a Bachelor of Law degree from the University of Nairobi, and I specialize mostly in commercial disputes ranging from public procurement, insolvency, tax, intellectual property, shareholder disputes, among others. Today, we are privileged to have César Pereira. He is a partner at Justin Pereira, Oliveira, and Tlamini in Sao Paulo, Brazil, and co-head of his firm's infrastructure and arbitration practices. He is the CISG Advisory Council Rapporteur for the opinion on the application of the CISG to government contracts. He is also a chartered arbitrator and a fellow of the Chartered Institute of Arbitrators, and the immediate past chair in the years 2019 and 2022 of the CIA Brazil branch. His work as counsel, arbitrator, or legal expert focuses on infrastructure projects, regulated industries, public procurement, and international contracts. And he has also authored or edited articles, book chapters, and books in these fields. He holds a doctorate and a master's degree in public law from PUCSB Brazil, and has been a visiting scholar at Columbia University, University of Nottingham, and George Washington University. He's a member of the board of directors for the Vis Moot Foundation. He's a fellow of the University of Nottingham's Public Procurement Research Group, and is on the editorial board of its Public Procurement Law Review. As you can see, we have a distinguished scholar with us, and we're very excited to meet you, César. I'm really looking forward to the knowledge that you're going to be imparting on us today, and we look forward to being enlightened even more. So I'll hand it over to you to proceed.
Thank you. Thank you, Oscar. Thank you, Ghada. It's a wonderful privilege to be here with Africa in the Moot again. I'm a big fan of Africa in the Moot. I'm a very enthusiastic supporter of the Moot in general. I have been participating in different capacities as coach or arbitrator, now since recently as director of as part of the board of directors of Vis East. And actually, my daughter was a Moody, pretty much around, probably around the time you were, Oscar. That was 2018, I think. That's when she was a Moody. And so I have seen from the other side as well the efforts that the students make into this experience, and I'm a strong believer that this is life-changing. It opens many opportunities. It gives you a type of structure of learning that you can't really match in most of the experiences that you have in law school. And so all those who are watching this, as Hada said, either live or later in the recording, I commend you just for being involved in being interested in this initiative. Now, I will start sharing my screen here. Let's see. Yeah. As you can imagine, I was very happy after being involved in the Moot for around 13 or 14 years. After all these years, I was very excited to see public procurement and government contracts as part of the Moot problem this year. I have been writing about this for about 10 years. I think the first time I wrote about this was in a book in 2014, and I've always been very curious about how the CISG, which is a body of rules that govern international sales, interplays with the rules that govern government contracts, which are generally domestic rules. Sometimes they're based on international treaties or on international uniform model laws, but they are basically domestic laws. And as you know, domestic law in the CISG normally don't talk too much to each other, right? And so if we are talking about government contracts, we need to understand how they work together, the CISG and domestic law. So I was really excited when I saw that this is part of this year's problem, and I hope I can share with you some information, and we can develop together some ideas about how this can work. Now, just to remind you about this year's problem, we have green hydro on one side and Equatoriana wind power on the other side. The claimant is an engineering company specialized in the planning, construction, and sale of plants for the production of green hydrogen. And in here, it entered into a contract with a government-owned company, Equatoriana Wind Power. That company was created after the merger of two other state-owned energy companies. And this Equatoriana Wind Power plays an important role in the public policy of Equatoriana regarding green energy. And so that's the background of this problem. It's not a simple private contract. It's a government contract between a government entity that is involved in the pursuit of Equatoriana's public interest with a private international foreign supplier of energy equipment and services. Now, this basically what happened in this case, there was a public procurement process which was conducted through a reverse auction. We will see in a moment what that is. After all of that process, green hydro was selected as the winning bidder and then entered into a contract with Equatoriana Wind Power. After that contract had been entered into, there was a political change in Equatoriana that led to a shift in the energy policy, a reevaluation of green hydrogen projects, and due to a series of facts, the government-owned entity, Equatoriana Wind Power, terminated the contract for several reasons. One was the delay or alleged delay in delivering final plans. And also, even if the problem is not entirely clear about that, but also based on its power as a government entity to terminate government contract without cause for public interest reasons. That termination led to a dispute, and that is what is being discussed here in this arbitration. So we have, as you know, we have a discussion in this problem about what law should govern this contract. If it is governed by Equatoriana law, meaning Equatoriana Public Procurement law, Equatoriana domestic law, or if it's governed by the CISG. In several discussions are involved in this topic. Just to give you a very quick timeline here, the whole thing starts with a request for quotation. As we will see, this is a very typical step in a public procurement process. This request for quotation or request for proposal or solicitation, this is basically a request for offers, for tenders. And in that started in 2023. There was a public procurement process that was made through a reverse auction. As you know, in an auction, if you're going to buy art in an auction, for instance, although there is one seller, there are many prospective buyers. All those buyers try to outbid one another until the moment one of them is the winner. In a reverse auction, it's basically the opposite. You have one buyer, which is in this case a government entity. You have several prospective sellers, and all those sellers, they keep reducing their price. Their bids are not higher than the previous bid, but they're lower than the previous bid, so that one of them will offer the best possible price to be paid by the government. That will lead to the selection of a bidder that will then be awarded the contract. And so that's another very important term that you need to understand. When we talk in arbitration about awards, we're talking about a judgment, right? Here, when we talk about an award, we are talking about the assignment to one of the bidders of the right to enter into the contract. The contract is awarded means that that one specific bidder acquires the right to enter into the contract with the government entity. So all that happened in this initial phase here and led to the signature, to the conclusion of the contract in July 2023. Many things happened afterwards until the arbitration was requested in July 2024, and the answer from the government entity came in August 2024, and that's where we are right now. As you know, the topics that were defined in Procedural Order No. 1 for discussion involve, as usual, two arbitration issues, jurisdictional issues, and two issues relating to the merits. And I'm not going to discuss all of them with you here today, but I will touch upon some issues that are related to item C in some issues that are related to item D. Is the CISG applicable to the agreement? And if so, have the parties validly excluded its application? Now, obviously, we need to start from the definition of the scope of application of the CISG, and is it generally applicable to government contracts, or are only private contracts covered by the CISG? Article 1.3 CISG says that neither the nationality of the parties nor the civil or commercial character of the parties or of the contract is to be taken into consideration in determining the application of this convention. So basically, the convention intends to be neutral as to the character of the parties or the contract, provided there is an international transaction, and provided that there is sale of goods, the convention should apply. In that underlying principle should also extend to the administrative or governmental character of a party or contract. This neutrality of the CISG should be understood as an underlying principle of Article 1.3, so that the administrative nature, the governmental nature of a party or contract is to be disregarded, just as the civil or commercial character should also be disregarded. If we need to base that reasoning on something in the structure of the CISG, we can go to Article 7.2 as the basis for the understanding that the underlying principles of the CISG fill gaps, internal gaps in the convention, and we can extend this underlying principle of Article 1.3 to government contracts as well. This is not a new thing. If you take a look at commentaries and case law, it's generally accepted that the CISG does apply to government contracts as well, provided that there is an international contract and there is a sale of goods, and that obviously either both parties or at least one of them is contracting state of the CISG. If only one of them is a contracting state, as you know, Article 1.1b CISG says that if the conflict of laws rules applicable to the case lead to the application of the law of the contracting state, then the CISG will apply to the contract. So all of that applies, is generally accepted as applying to government contracts as well. We will, but as I have said many times, that is just the starting point. Accepting that the CISG generally applies to government contracts is only the start of our discussion. There are many things that come afterwards and that are related and involved in this year's problem. Now, normally, government entities are buyers, right? But they can also be sellers. It doesn't really, of course, for this discussion in this year's problem, it doesn't really the fact that a government entity can be a seller doesn't really play much of a role, because it's not the problem that we have. But it's good for you to understand that governments can also be sellers, and you can find case law involving contracts in which governments were selling equipment, selling internationally, selling things that fall under the scope of application of the CISG. And so just in this first part, it's important for you to understand that the nature of the contract or of the parties as administrative or governmental does not play any role in the application of the CISG. And that has many repercussions when we apply the convention. Now, if we go to Article 2 CISG, we see that there are some exclusions that might create some doubts about how the CISG can apply to government contracts. And, three of them are important. I'm going to comment in more detail two of them, letter B and letter C, sales by auction and sales on execution or otherwise by authority of law. But before we go there, I would just like to comment that Article 2A is also not an exclusion that would lead to the non-applicability of the CISG to government contracts. Why would we care about Article 2A? Basically, because governments normally do not buy goods for resale, right? Governments buy goods for use. And we could think that if a government buys goods for its own use, that would fall under the exception of Article 2A. But that's not how this rule is interpreted. It does not extend to sales for personal use of an entity, such as a corporation, a company, or a government. And so when the convention excludes goods bought for personal, family, or household use, it's not dealing with goods for use of a collective entity such as a government. That applies even to something that would look very much like this. For instance, if a government buys internationally goods for use at an ambassador's house, that would not be a household use. That would still be for goods bought for the professional use of an entity, namely the government. But let's talk about Article 2B, sales made by auction. Here we need to understand what is the intention of this rule, what is the purpose of this rule, and how that interplays with government purchases. Now, before we move on, let's stop and understand a little better how a public procurement process works. As I mentioned to you, it generally starts with a request for tender, which can be called a request for quotations, request for proposals, a solicitation. This is a call for the market to make offers for the government. Now, after that notice is out in the market, a bidder will receive that notice, will plan and prepare its bid, will write its tender response or its bid, will submit the bid. Then there will be a process which is internal to the government entity pursuing that procurement process, in which the buyer, the government, will evaluate the bids. That generally follows a set of rules that will either be in regulations or will be set out in the bidding documents, in the request for tender, request for proposals. The criteria will be set out there. The procedure that has to be followed will be set out there. And the methodology for defining who the winning bidder is, which can be sometimes a sealed bid, a sealed competitive bid, in which, let's say, if we think about a more analog system, each one will put their bid in an envelope. Those envelopes will be sealed. They will be delivered to the government entity that's conducting that process. In that entity will open the bids, compare them, and declare one of them as the winner. There are many methods for that. Reverse auction is one of them, and we will look at that. The buyer will evaluate those responses, and then the buyer will award the contract, award the tender. This is a very important stage for us, and we will see later why. And only after that award, the contract will be concluded and the performance of the contract will start. And so you see that there is a long procedure that leads to the award of the tender, and only after that the contract is formed and is performed. Now, if you think about the CISG basically deals with the formation of the contract and its performance, right? So the CISG enters into this process here at number 8 in this stage, right? Only at the time the contract is formed. Obviously, there are relevant facts that take place before that. As you know, the CISG also concerns itself with the negotiations leading to the formation of the contract. And so this whole process before the formation of the contract is not completely irrelevant, but the focus of the CISG is basically formation and obligations. Now, as I mentioned to you, if we think about auctions, we're thinking about a method of selecting the contractor, or a method of contracting in which bidders will increase their offers in turns. The seller will not necessarily know the identity of the buyer until it ends the auction, declares one of them the winner, and then the buyer, then the seller will discover who that buyer is. That's usually what happens if you're participating in a bid, in an auction for any type of good. Now, in a reverse auction, the process is the opposite. The bidders will lower their prices in turns, and if you think about reverse auction as a method of selecting the most advantageous offer in a government contract, the procuring entity will generally know the identity of the seller because in order to make the procurement process more efficient, sellers will need to show their ability to perform the contract before they enter into this procurement process. And contrary to what happens in an auction, in which the applicability of the CISG cannot necessarily be anticipated, in a reverse auction, normally the procuring entity knows whether a bidder is coming from another country and is potentially subject to the applicability of the CISG. Now, one point that, as far as I understand, is not clear in the problem, and I don't know if it's going to be clarified or not, is whether this reverse auction is electronic, online, or not. The reverse auction can be analog, can be in person, it can be done in a room in which bidders will lower their prices, but that's not usually what happens. In the international experience in public procurement, reverse auctions are normally electronic or online. And that means bidders are enrolled at a certain platform and they make their bids, lowering their prices online, right? This is the definition, and it's important that you know that there are some international documents that you can review for this purpose. This is a definition that comes from the UNCITRAL Model Law on Public Procurement. We are all very much used to the model law on international arbitration. Now you have another model law. It's the model law on public procurement. And that model law contains a definition of reverse auction, specifically electronic reverse auction. Now, that electronic reverse auction is a phase preceding the award of the procurement contract. You remember all that sequence of phases. The reverse auction comes before the award of the contract. It's a phase for defining who the contractor will be, but the formation of the contract will come after this. It will come after the selection, after the award, and it will be the formation of the contract. The conclusion of the contract will be the next step in that process. Another document that you may want to know is the agreement on government procurement of the World Trade Organization. This is unlike the model law, which is basically soft law, and it's a reference that governments can implement or not voluntarily. This agreement is an international treaty. It's a plurilateral treaty that involves a certain number of countries. As far as I know, Equatoriana is not a member of the agreement on government procurement, but you can find some good definitions here. And one of them is electronic auction. And the electronic auction is a process that involves the use of electronic means for the presentation of new prices or new values that can either go up, and that would be an auction, or down, and it would be a reverse auction. In reverse auctions, bidders need to comply with certain minimum requirements. and then if they win based on the evaluation criteria that will be defined in the bidding process documents, then they will be considered for an award. The EU directives, especially the Directive 2014-24, also defines electronic auctions or e-auctions, and they define reverse auctions when the economic operators compete to offer their products by revising the prices downward. And so we all know what a reverse auction is now, right? It's part of the public procurement process, and it's a method in which prices go down in turn. Now, why, and this is very important, why Article 2B CISG excludes sales by auctions? Basically, those auctions were traditionally held in one place, governed by the law of that place, and there was no significance to the parties' places of business because they were all there making that purchase of an item that was being sold by the seller physically there. That was an auction was typically a local sale in which the international nature of a party was irrelevant. And in addition, traditionally, there was a lack of knowledge of the seller about the identity of the bidder, of the buyer. And so the seller could not really expect the CISG to apply or not apply, or could not anticipate the application of the seller. That means that this rationale for the exclusion of auctions does not extend to public procurement, because in public procurement, the identity of the buyer is indeed important. The identity of the buyer is defined beforehand, so that the application of the CISG is perfectly can be perfectly anticipated by the seller. It's useful also to remember that some arguments to exclude some arguments not to exclude government sales or government auctions from this Article 2B exception may not be entirely correct. So if you take a look at this argument here, that says that a public procurement is not under the exception of 2B because the fundamental characteristic of an auction, which is the chance for a bidder to outbid the current best bidder and move forward with the competitive bidding, that's not is not entirely true, because if we think, okay, what is the argument here? The argument is, in public procurement there is only one bid, and the government will look at those bids and then decide which one is the best offer and enter into the contract with the winning bidder. that's not entirely true, because what we have just seen is that reverse auctions are a typical method of public procurement. And in reverse auctions, there is really the chance for a participating bidder to outbid the current best bidder. And so if we take this argument here as an argument in favor of applying the CISG to government contracts, I understand this argument can be rebutted by demonstrating that in a reverse auction there is indeed this competition that's typical of an auction. It's only the flip side of an auction, right? It's an auction that goes down instead of going up. So when we have to decide whether auctions are or not, or reverse auctions are or not excluded by Article 2B, we need to look at other things. We need to see what specifically justifies this exclusion of auctions, which is normally associated with the idea of a local sale in which the parties are all together, and the international nature of the sale is irrelevant, and see how that interacts with a reverse auction. And we may come to the conclusion that, as Pascal Hachem says here, that online auctions are always outside the scope of Article 2B, because online auctions are not local auctions, in which local sales, in which the international nature of the parties is irrelevant. But we don't know in this case, in this problem, we don't know if, at least I don't think we know, if this auction is online or in person. If this reverse auction is in person, this argument here about online auctions will not apply, and we'll still need to discuss whether reverse auctions and auctions can be the same thing. And it's also interesting to notice that even if this case is an online auction, there is case law that applies very literally Article 2B, saying that even in an online auction, Article 2B excludes the application of the CISG to an auction, right? And so that this case, for instance, from the Netherlands, excludes the CISG even in an online auction. Now, so just to wrap up here, basically what we need to understand is whether the fact that a reverse auction is part of the procurement process, it's part of the selection of contractor process, if that means that it's not an auction for the purposes of the CISG, or if even being a reverse auction in which prices go down instead of going up, the reasoning behind Article 2B extends to reverse auctions as well. I have already written to the effect that reverse auctions are not excluded from the CISG, but that there are arguments that can be made for both sides in that regard. There are many similarities between reverse auctions and auctions. And as I said, there is case law applying very literally the exclusion of Article 2B, even in online auctions, in which, as I mentioned, scholars understand that the reasoning behind Article 2B should not apply. So even in online auctions, in which there is a lot more discussion than in reverse auctions, even in that situation, there is case law excluding the application of the CISG. Now, the next point I'd like to discuss with you has to do with Article 2C. Article 2C can create some confusion about whether the CISG can apply to government contracts or not, because it says that the CISG is excluded of sales on execution or otherwise by authority of law. You may know that when governments enter into contracts, they are obviously they are entering into a transaction, into a commercial transaction, but they are also exercising their mission as governments, right? And so we could maybe say that a government contract is always a contract, an activity that is made by authority of law, right? So if we were to interpret this rule here very literally, where we might come to the conclusion that if a government is involved, there is an authority of law behind the government, and that means the convention would not apply under Article 2C. That is not a very easy argument to make for many reasons. And one of them that's very interesting is that, as you may recall, the CISG has 6 different authentic versions, right? And they're all equally authentic. None of them has any precedent over the others in theory. And if we, okay, let's go back to the English version here. Sales on execution or otherwise by authority of law. If we look at the other versions, and I just added here machine translation, so I can't really vouch for, especially for the Arabic, Chinese, and Russian versions. But if we trust the machine, and if we trust that these translations are relatively correct, we see that this on authority of law only exists really in the English version, right? In Spanish, it's just judicial sales. In Arabic, it's sales following seizure or other sales conducted by order of the judicial authority. In the Chinese, it's sales pursuant to a writ of execution or other writs according to law. In French, upon seizure or in any other manner by judicial authority. And so we see kind of a trend here showing that this authority of law is actually a lot narrower. This idea is a lot narrower than it seems when we read the English version. And so these are basically compulsory sales that are made to enforce orders or awards. Now, it's interesting. I had the chance to write an article with Professor Ingeborg Schwenzer earlier this year about how to interpret diverging but equally authentic CISG texts. And in there we came to the conclusion that if you have this type of divergence, we should look at the English version, which was the primary language of the diplomatic conference in the preparatory works of the CISG. the French text was also very, very much discussed. We should also place some weight on the language adopted by the parties in their contract, because that may lead to an implied choice of one of the authentic texts of the CISG that the parties intended to use when there are different versions. And so if we take these standards here as guidance, considering that the contract is in English, we might come to the English version of the CISG and read this authority of law in terms a little broader than what stems from the other versions. Or if we try to interpret the CISG in a manner that will accommodate these differences between the versions, we might use these different versions to interpret what execution or otherwise authority of law means. And if we, in this latter option, we would come to the conclusion, which is something that we find normally in commentaries about the CISG, we would come to the conclusion that this exclusion here is only related to compulsory sales that are made in the enforcement of orders, and not any type of contracts that a government enters into in the use of its government powers. So, so the conclusion that you normally find in scholarship is that authority of law is not the mere exercise of government powers in entering into government contracts. But of course, as I said, there may be an argument to be made based on the difference of the English version in this regard, comparing with the other authentic versions, which are more specifically related to judicial sales. And so this is basically what I mentioned before, the implied choice of the CISG text based on the language that the used in their contract. Now, the UNCITRAL Secretariat is one of the sources in which you will find the conclusion that only transactions that are directly mandated by law or by an order of a government authority are excluded by Article 2C. And this does not, all this discussion here is not based on those different languages of the CISG. It's an interpretation of the English version, but it coincides with what you can find in the other languages as well. This is what the Secretariat commented on that provision. 2C excludes sales on judicial or administrative execution or otherwise by authority of law, because those sales are governed by special rules in the state where that sale is made. And as I said, generally, public procurement is not mistaken for authority of law. These are activities that are adopted by governments in a commercial environment, and they're not to be mistaken by an activity on the authority of law per se. You can find case law dealing with Article 2C, and normally the conclusion is that Article 2C does not exclude public procurement in general. Now, so just to conclude this section, the points that you should keep in mind are: does a reverse auction fall outside the meaning of an auction for the purposes of 2B CISG? So in here, you will find things that make reverse auction and auctions similar for the purpose of 2B, as well as aspects that will distinguish reverse auctions from auctions under 2B. Now, could sales contracts resulting from a tender process, from a public procurement process, be a sale on authority of law pursuant to Article 2C? Here, there are all those discussions regarding the different languages of the CISG and the authorities, scholars and case law, to this effect that public procurement and authority of law are two different things. And finally, what if the reverse auction is online, not in person? Does it make a difference? As we saw, scholars understand that online auctions are not covered by the exception of 2B. However, there is case law saying exactly the opposite, that even online auctions are excluded. Okay, and the second point I would like to make with you is related to the exclusion of the CISG. In here, the interesting thing is to understand how Article 6 CISG applies to this interplay between the CISG and public procurement rules, public procurement laws and regulations that are usually domestic and that tend to apply to government contracts made by a certain government. So here, the premise that we need to understand is that if government contracts, well, we went through Article 2 CISG, right? If government contracts are generally within the scope of application of the CISG, the rules of the CISG about exclusion, about interpretation, Article 8, about usages, Article 9, all those rules will apply. And the CISG itself will be the law that will define whether the CISG was excluded or not. So in order to know in a specific case, like our problem here, whether the CISG has been excluded or derogated or not, we need to look at the CISG. We need to go to Article 6, understand how it works, and see how see what the contract that we have in hand says. Now, and this is precisely what PO number 1 asks us to do. Have the parties validly excluded the application of the CISG? Now, as I said, Article 6 allows the parties to exclude or derogate or vary the effect of any of the provisions of the CISG. And in this is basically the guidance that we need to take into consideration. We need to look at Article 6 understand what it says, and look at the contract and see what the contract did. That exclusion or derogation may be explicit or implicit, and CISG Advisory Council Opinion number 16 has examined in a lot of detail how that works. What is an intent to exclude the CISG, and so that clear intent should be inferred, for example, from express exclusion, the choice of law of a non-contracting state, choice of an expressly specified domestic statute or code where that would otherwise be displaced by the CISG's application. Especially this number 3 here, choice of an expressly specified domestic statute or code, can be very important here, because usually in government contracts, there is a reference to the application of the domestic public procurement law. That happens also in our problem here. Even if the problem generally talks about the application of Equatoriana law in general, the contract also has a reference to the request for proposals, in which there is the provision that the domestic public procurement law of Equatoriana applies to the award of the contract. And we saw earlier, we saw what that means. The award of the contract is a stage that follows the whole process, the whole public procurement process, and is the immediately it's the stage immediately prior to the conclusion of the contract. And so if we say that the award of the contract is governed by domestic law, we will need to understand how much of the CISG is excluded or derogated by that application. Now, there are, this is not relevant for our case, but there are government contracts in the international experience in which the CISG is expressly excluded, like this one, or other cases in which there is a choice of law of a country that is a contracting state of the CISG without any express exclusion of the CISG, which means the CISG could apply. There are cases in which specifically this issue has been discussed. And so in this case here, Interral versus Select, this is a case between a Russian state-owned company in its Ecuadorian subsidiary in a contract with an Ecuadorian state-owned company. And in that case, the arbitral tribunal decided that the parties had excluded the CISG because they had made their contractual relationship subject to the LOS-NCP, which is the domestic public procurement law of Ecuador. And so in this specific case, the reference in the contract to the domestic law was considered to be an exclusion of the CISG. There is scholarship also in the sense that if the parties choose a specific national regulation that's incompatible with the CISG, that amounts to an exclusion. But my understanding about this is a little more nuanced. I believe, considering what the CISG Advisory Council did. Let me show you here. What the CISG Advisory Council did in opinion number 16. I think it's important to distinguish if the body of law or statute mentioned in a contract as applicable to the contract has a similar scope to that of the CISG or not. And so if the contract says that it's subject to a public procurement law that does not cover the same scope as the CISG, meaning does not cover the formation of the contract, the obligations of the parties, termination, damages, basically the scope of the CISG, that will not be an exclusion, in my opinion. It will not be an exclusion, but it will be only a derogation of the provisions in the CISG that are incompatible, that are contrary, that cover the same issues of the domestic public procurement law that was mentioned in the contract. So based on that premise, I think we should understand that a contractual reference to domestic public procurement laws will not, in principle, not amount to an Article 6 exclusion, but only to a derogation of the conflicting provisions of the CISG. Basically, we will only consider, in my opinion, we will only consider that there is an exclusion if the local domestic public procurement law that's mentioned in the contract contains sufficiently broad system of contract law that can replace the CISG. Otherwise, there will be this interplay. There will be only a derogation in the domestic public procurement law will apply, except if there are provisions in the CISG that are not conflicting with that public procurement law. So areas in which that domestic law does not cover or does not give a solution, that may be sought in the CISG. For instance, if a domestic, it's very common that domestic public procurement laws do not cover everything. Sometimes they only cover the selection phase and do not cover the formation of the contract or the performance. Sometimes they cover some aspects of performance. They may cover termination, for instance, but they do not talk about damages. They do not talk about foreseeability of damages. They do not talk about mitigation of damages. There is a wide variety of scopes for domestic public procurement laws, and we should be mindful of that. And we should we should not, in my opinion, we should not automatically consider that a reference to a domestic public procurement law amounts to an exclusion. And so when we talk about exclusion for the purposes of this problem, for item D of that Procedural Order number 1, this is basically what's going to be in discussion. Is this an exclusion? Is this a derogation? What is excluded, or what is derogated if it's not an exclusion, and that will, in my opinion, depend on a case-by-case analysis. In this article here, this Belgian professor understands that by referring to the Belgian national regulation, there was an exclusion in a contract. There was an exclusion of the CISG, basically because, according to this Belgian professor, the Belgian domestic public procurement law covers also issues related to the performance of the contract, not only the selection of the contractor. Here in the problem, we have a provision saying that the public procurement law of Equatoriana applies to the award of the contract. So we will need to understand, right? What does that mean? The award of the contract. Does that mean that the CISG has been excluded entirely? Does that mean that it has only been derogated with regard to issues relating to the this part of the process that's covered by the domestic law? These are all issues that are open for discussion. There's another thing that can be interesting here too. Remember that we are always talking about the implied intent to exclude here, right? Now, as you may have noticed, there was a model contract that was used by the Ecuatoriana government. And that model, and that's very common. Many governments have model contracts because that way they ensure uniformity in their contracts, right? So there was a change in that model contract, and the point to be discussed is whether the change in the model contract shows the intent to exclude the CISG. That's also something that I understand it will be interesting to discuss in this case. Now, the final point I wanted to make with regard to this issue here is if we take into consideration that according to the contract, the award of the contract is covered by the domestic law of Equatoriana. And remember, the award of the contract is basically everything that happens until immediately before the formation of the contract. Could we say that Articles 8 and 9 CISG can be applied to the interpretation of the negotiations prior to the award of the contract to the winning bidder? So you remember that in this case, there are negotiations that led to the reduction of price in exchange for the waiver of termination without cause, and many things that are related to the negotiations. Can we say that Articles 8 and 9 CISG do not apply because that phase of the contracting process, according to the contract, would be governed by domestic law, not by the CISG? That is also something to discuss. Now, as you can see, and I would recommend that you take a look at this article here. You can find it online. This is an article I published last year, and there are lots of cases that are mentioned here. One of them is this one here. This is a 2022 case in which a court in New York decided that there was no clear evidence that there was mutual intention to exclude the application of the CISG in order or based on the contract that had been submitted to the court here. Now, the final point I'd like to make, and that's just a reminder, is that if a provision excluding the CISG is not entirely clear, there may be an argument to be made based on contra proferentem, based on the idea that the government entity, is the one that drafts the contract, and that provision regarding the application of the CISG should be interpreted against that party. Now, that general idea of contra proferentem in government contracts may be very seductive, right? We may think, yeah, it makes a lot of sense because governments usually draft the contracts and make it like take it or leave it for contractors, but that's not entirely true, right? The contra proferentem principle is based on the existence of ambiguity. It can be useful if it's very clear that one of the parties was the one that unilaterally introduced a certain rule, but it's not entirely clear that it should be applied in government contracts because in some cases there may be a great deal of government contractor interaction, negotiation, and drafting of the contract together, and so and that may be the case in our problem here. As you know, there was an extensive negotiation phase, and that may be used to exclude the applicability of contra proferentem. And so, just to conclude, things to remember here: could the public procurement law from Equatoriana exclude the applicability of the CISG? Could the modification in the model contract amount to an implicit exclusion of the CISG? And could a contra proferentem reasoning be applied to support the application of the CISG in this case? I thank you once more, Hada and Oscar, for the privilege to be here with you. I will stop sharing my screen here, and I will be more than happy to discuss with you any questions that you may have. Thank you.
Thank you, César. For now, I don't see yet questions in the chat, so let's give it a couple of more minutes. Maybe someone would like to ask anything with regards to this presentation.